The NLRB, which is the National Labor Relations Board, recently handed down the decision that impacts severance agreements. And there are lots of people that are super excited about it and think it's going to make a big difference in how employers issue severance agreements and on employee severance agreements. In this video, I'm going to tell you why I don't really think it's going to make that big of a difference. I'm Anne Marie. I'm the anti-HR lady. I'm a recovering attorney and HR executive. I teach my clients how to exit discriminatory hostile work environments with severance without filing a lawsuit or hiring an attorney. When an employer provides an employee with a severance agreement, in most cases they're doing so because they believe they have some type of legal exposure, and they're seeking to buy that legal exposure back from the employee. They usually present the employee with agreement that bars them from talking about the former employer in a negative way of any kind, keeping any contents of the agreement itself confidential, and in exchange for that and many other provisions, the employee is provided a monetary payment. The clause that usually bars the employee from saying anything negative about their employer is called a non-disparagement clause. There's usually also a clause called a confidentiality clause that also says that the employee must keep everything that they learned at the employer confidential, and also usually says, again, that they can't say anything about the contents of the agreement that they have signed. A recent decision from the National Labor Relations Board puts some limits on how these clauses can be written in the future. However, I want to be clear that the decision does not bar employers from putting non-disparagement clauses and confidentiality clauses in severance agreements. I've seen lots of places where people have talked about this decision as if it erases those clauses from agreements, and that is not the case. I could say that employers would probably never pay employees severance if they could not put some limits around what an employee could say about the agreement and what an employee could say about the employer after they left. So nothing in that decision says that employers cannot have non-disparagement clauses and that they cannot require confidentiality. However, it does put limits about how broadly that language can be written and what they can and cannot keep employees from talking about. What this decision basically does is it ensures that employers are not allowed to bar employees from saying things about their separation from an employer that they are legally allowed to say. And it also says that employers can no longer tell employees that they cannot talk to other employees about the contents of a separation agreement that they may have all signed at the same time. And this decision applies not just to the separation agreements going forward, but also separation agreements which may have been signed by employees in the past. So it's retroactive. One thing that people should understand is that this decision could result in employers giving less severance benefits than they used to, unless they really feel that they have legal exposure. Many times employers in the past give severance agreements kind of just as a matter of course to limit their liability, whether they believe they have any liability exposure or not. This decision is likely to result in less severance agreements being given to employees in the future rather than more. What this decision means is that non-disparagement clauses and confidentiality clauses will need to be written narrowly going forward, and they will need to be much more specific. They will not be able to be written in the broad manner in which most of these clauses have been written in the past. What this means is that non-disparagement clauses and confidentiality clauses will likely be written much more narrowly in the future. They will likely be more specific and cover specific things and topics and situations that employees may be barred from talking about, rather than blanket provisions saying you can't talk about anything. But I don't expect that they will just disappear from severance agreements. I hope this video has been helpful. Of course, as with all of my videos, this is not legal advice, and this is just my opinion based on my law degree and my 20 plus years in human resources management. You can take it with a grain of salt or not, but this is my understanding of the decision, which I have read, as well as opinions about the decision, which I have read. I hope you guys find this helpful. I'm Anne Marie, the anti-HR lady. As I always tell you, HR is not your enemy, but it's definitely not your friend. I am. If you enjoy this video, please subscribe. And if you're on YouTube, please subscribe, like, and hit the notification bell so that you're aware when new videos drop.